puts the life of the child victim at a halt and causes constant distress to the child. And the child is put in an impossible, paradoxical situation in which the child is constantly reminded that he or she must remember every detail of the abusive event, so he or she can deliver her statement during the court trial. But on the other hand, it is expected that life should go on as usual. The child should get on with his studies, etc. So this is experience that children have explained and illustrated in researches, and is an extreme trauma for the child. The third is the hostile cross-examination, the intimidating, degrading, oppressive, and traumatic to the child witness, often in a language which is incomprehensible to the child, and of course in a very unfriendly environment, courthouse. Then I should like to add to this two additional elements, which is not within the framework of the justice system, but it relates to the lack of appropriate therapeutic services for the child victims and his and her family, which may also be traumatized by the abuse, and the non-availability, particularly in cases that don't meet the criteria of the burden of proof within the justice system. And on the other hand, you have the lack of expert knowledge and technology for medical evaluation, particularly in historic child sexual abuse cases, which are extremely difficult to investigate. To understand the basic concept of Barnahus, one needs to appreciate the uniqueness of the crime of the abuse of the child. This crime is extremely unique in the sense that the child victim, contrary to victims of other crimes, is not likely to bring charges against their offenders. In fact, and we all know this, it is extremely difficult for the child, because of the vulnerability, to disclose the offense. And if you really look at it, and it has been demonstrated through various research, there are many, many more reasons for the child not to tell, not to disclose, rather than to disclose. I won't go into this. There are so many factors at play there. For example, the lack of vocabulary, the lack of knowledge, etc., and the closeness to the perpetrator. And then we come to the second characteristics of this crime against children, that the perpetrator is most often in the circle of trust. We are talking about crimes against children, in most cases, which are committed by persons that in positions of trust of the child. It may be within the wider family, or it may be in schools, the neighbors, in sports, someone that the child actually has put his trust in. And the third aspect is the lack of evidence, other than the child's disclosure in child abuse cases. And we know that medical evidence exists in less than 10% of cases and are only conclusive in less than 5% of all cases. Other hard evidence of witnesses other than the child victims very rarely exist. So the general picture is like this. The child victim doesn't act like a victim. The perpetrator doesn't look like a perpetrator, and we have no evidence. That's our problem. But it is not only the nature of the crime which is unique, it's also the nature of the intervention, because child sexual abuse, or abuse generally, is not only a judicial issue, but requires multi-agency intervention. We all know that the child victims disclosure is the key for ensuring the safety of the child, to provide the physical and psychological recovery, to uncover the crime in terms of criminal investigation, prosecution, and sentencing, and preventing the offender from reoffending. All the different agencies in society that have a role to play, the child protection, the medical profession, the police, the prosecution, they all need to have the child's account. And this creates a situation where the child is subjected to repetitive interviews by many professionals in different locations that may have extremely harmful effect for the child. It subjects the child to a very re-victimized situation and can cause re-traumatization. It's very stressful on the child, but it's not only harmful for the child, it is also harmful for the criminal investigation per se, because repetitive and unstructured interview can distort the child's narrative. And we know that when children are interviewed by people who are not trained and are not applying structured interviewing protocol, you are subjecting the child to suggestible justibility and leading and misleading questions, which creates discrepancies in the child's story, and the disclosure becomes contaminated, and therefore the evidential value of the narrative of the child diminishes. And this, of course, has catastrophic implications for the criminal investigation. On the top of this, the child oftentimes is taken to very unfriendly environment to be interviewed, environments which may be harmful even for the child, like police station. All children know that it is criminals who are taken to police stations, and they may understand this as a message of that they are responsible for what has happened to a greater or less extent. And that is sort of exacerbates the impact, the negative impact of the abuse on the child's makeup. Now, Barnahus is designed to deal with all these issues. It was founded in 1998, rooted in the principles of child-friendly and multi-agency features of the children's advocacy model in the USA, with the overt aim of integrating the long-standing US tradition of investigative approach in child protection and criminal justice. And on the other hand, the great legacy of the Nordic welfare model and the principles of the United Nations Convention on the Rights of the Child. And now it is promoted by the Council of Europe, and in particularly through the Promise Project through the European Union. Now, what are the guiding principles behind Barnahus? The cross-cutting principles of the best interest of the child and the right of the child to be heard in any judicial and administrative proceedings. These are the basic principles underlying the Barnahus concept. The concept is based on the premises that all the agencies that have a role to play in dealing with child abuse, they work together under one roof in a child-friendly facility. In Iceland, it was the government's agent for child protection, the state police, the state prosecution, the police department in Reykjavik, the university hospital, etc. And it was set up in a residential area, in a normal residential house, designed to be a safe place for children, to create an atmosphere of child friendliness. It is extremely important that the environment for the child is positive in order to reduce the level of anxiety. We know that the more relaxed the child is, the more likely it is that we will receive the full disclosure from the child. Now, the functions of the Barnahus, at the core of the Barnahus is the joint investigative interview. We have also the medical examinations, the medical facility. Victim therapy is, of course, an extremely important part of this project. Family counseling and support, and also consultation, advice to other agencies in society that are dealing with this issue. Awareness raising, education, training, and research are among the features that also are to be found in Barnahus. Now, if you look at the ingredients of Barnahus, the principles, as I've said, the aim is to harmonize the cross-cutting principles embodied in the UNCRC on the one hand, and the human rights principle of the fair trial on the other. We do this by a child-friendly arrangement for eliciting the child's narrative at the pre-trial stage, enhancing the evidential value of the child's testimony by avoiding unduly delay and applying evidence-based interview protocol, by audiovisual recording of the child's testimony with the aim of avoiding repeated questioning during the court hearings. And this we do under the conditions required to ensure the due process, that is by representation of the defense and allowing for cross-examination. Now, the court hearing or the joint forensic interview is arranged in slightly different manner in European countries with regard to the implementation of Barnahus. And basically, there are two models. The model where the court judge is in charge of the procedure. So the interview takes place under the auspices of a court judge. But there is also another type of implementation, which is to be found in, for example, all other Nordic countries, in Norway, Sweden, and Denmark, which says that the interview or the hearing is conducted by the prosecutor or the police. But in all instances, we have the opportunity for the defense to take part in this process, and also the representative of all the other agencies that have a role to play in this, the prosecution, the police, the child protection, and of course the child's legal advocate. The one interview model where the court judge is in charge, this would then be a part of the main proceedings in the court if an indictment is made. It has a good solid base. So does the two interview model. We can look at the pros and cons. I'm sorry, the time limit prevents me to go into further detail in analyzing these two different models. But basically, the one interview model where you have the judge is in charge, the positive aspect of that is that you can do with one interview for the child. And you have the presence of the judge, so the principle of evidential immediacy is very much preserved in this arrangement. But the cons are that the police and the defense get the evidence from the child at more or less at the same time. And this can create difficulties when interrogation of the suspect. Also, it is a problem oftentimes that it causes increase in the workloads of the judges, which may result in a longer waiting time. The two interview models has its advantages. Some argue that this model accommodates better investigation because the child will have to come twice and may remember additional information in the second interview. And also it creates a better or more effective process for effective interrogation of the accused. However, the argument against would be that the child needs to give 2 interviews, which can be hard on the child, and the lack of evidential immediacy due to the absence of the court judge, who then would need to rely totally on the video audiovisual recording. Now, this forensic interview will be evidence in chief during the court proceeding if the case is taken to court. The goal of forensic interviews are maximizing reliable information, minimize stress and contamination of the child's disclosure. We use structured interview protocols, and there are quite a few interviewing protocols around. These are evidence-based. They address issues like suggestibility, memory, and language issue, adapted to the age and development stage of the child. And so they are, in short, designed to enhance the evidential validity of the child's narrative. Forensic interviews are always implemented by trained forensic interviewers. They can be child aspects, like in Iceland, where there are psychologists and social workers that are trained in forensic interviews, or the police, like in the other Nordic countries, that are also specifically trained and very experienced in interviewing children. And very importantly, we must I can see I have a message here. Need to attend to. Yes, we must include in this process the cross-examination. Let me see. Yeah, okay. I see there is some. It has taken on live on its own my slides. Yes, the cross-examination needs to be done there as well. Now, let us see. I've been here describing interviews and hearings of child victims that have fully disclosed abuse and have identified the abuser. But as we know, oftentimes this is not the case. The child only discloses partially, and in those instances, we offer what we call explanatory interviews, interviews which are only done by for the child protection to evaluate whether there is a cause for having a court hearing. Now, just to give you an idea of the interviewing room, you can see a photo of the interviewing room. I'm sorry, I can't understand why my slides keep on moving all the time, but this is an example of an interviewing room. The child victim would be the only one with the interviewer. You can see the camera there in the corner, and the court judge or the prosecutor in charge of the procedure would be monitoring the interview on the screen, together with the defense and the representatives of all the agencies. And this is an example of a setup of a monitoring room. Now, this can also be done differently if the court judge prefers to be physically present in the courthouse. It is possible to have the child being interviewed in Barnahus, and through IT technology, you can, of course, have a court session there. Now, just to give you an idea how
Ma l'Islanda non fa parte della roba, Islanda.
How effective this procedure is, I will here show you the picture of the speed of this process. This is from Iceland, and it shows you the time from the disclosure or when the police asks for forensic interview and hearing in cases. And you can see that almost half of the cases, this happens within 1 week. The child gives his or her disclosure or statement within 1 week of the reported abuse. Additional 30% within 2 weeks, and this remaining cases, almost all are completed within 3 weeks. And this means that the child victim of abuse can, in fact, has completed his or her role within the justice system in most cases during the first 3 weeks of the case. Now, we also offer.
Please keep your microphones off.
Hello. There are some.
Okay, you may continue, Mr. Gudbrandsson.
Can I continue?
Yes, you may continue.
All right.
Thank you.
Now, I won't. I know the time is passing, and I just want to know that let you know that in the Barnahus we also have a specific room for the investigation of the physical or examination of the physical examination, and particularly this is so with regard to historical sexual abuse. We use the video colposcope where the child is awake during the whole procedure, and this has a very therapeutic effect. It means that the medical professions who are conducting the physical evaluation, they can communicate with the child during the process. We never use anesthesia, and this has a great positive impact for the child, because the child can be convinced that she or he will be perfectly healthy, and there will be no long-term negative impact with regard to the physical side in far most of the cases. Now, victim therapy and family counseling is an integral part of Barnahus. Normally, a trauma-focused cognitive behavior therapy is applied, and very importantly, this is therapeutic services is offered immediately, only a few days after the investigative part, after the forensic interview is over. The child does not need to worry any longer about the investigative part, and we can concentrate on the healing process. So the first, there would be an assessment, and then a treatment plan accordingly produced, and the child and the non-offending parent and family members would be able to receive help as well. Now, Barnahus has, as you know, assumed a key role in the justice as well as the child protection system in all of the Nordic countries. And allowing for some difficulties in definition, Barnahus can now be found in about 70 locations in all the Nordic countries, and now in all the Baltic Sea countries, and the countries like in Europe, like Hungary, in the south, Cyprus, in England, Ireland, and Spain, Germany, and potentially more, like Slovenia, Scotland, etc. And as I mentioned before, this is recommended by various bodies. Very importantly, Barnahus has developed differently in diversity in the different countries, There are diverse paths and implementation paths of coming into being. The role of the state, the regional and the local authorities may be different from one country to another, as does the legislative framework. The affiliation of the different partners, the nature of the collaboration, these may be all different. Very importantly, the target group. We originally started by victims of child sexual abuse, but now Barnahus addresses all kinds of abuse and neglect. And that's very important, that all child victims have access to Barnahus. I should emphasize that it is oftentimes quite possible to implement Barnahus without any legal reform. When we started in 1998 in Iceland, there was no legal reform. Neither was it in Norway, nor in Sweden. Denmark did introduce specific legal professions, including which mandates testimonies in Barnahus, which was extremely important piece of legislation. And now we have, for the first time, an attempt being made to introduce a comprehensive draft act on Barnahus, which is now being debated in the Parliament of Slovenia. And I would very much recommend you to have to get a copy of that, because that's very instructive on an excellent way in which this could be introduced. I would like to emphasize that Barnahus is not a recipe for the cookshop of the future, but rather it brings us evidence-based ingredients to avoid re-traumatization of child victims by child-friendly and multi-agency response. It has proven to be transferable across borders and viable in different cultural, legal, and social environment. And extremely importantly, evaluation studies that have been carried out in Sweden, in Norway, in Iceland, for example, have shown an increased level of social awareness with regard to child abuse, higher level of prosecutions and convictions, but what is most important, better outcomes for child victims and their families. I would, by way of concluding, I want particularly to highlight the importance of the PROMISE project, the European project for implementation of Barnahus in Europe. It's the first systematic attempt to bring together European states for the purposes of implementing Barnahus. And the PROMISE project has developed European Barnahus standards, which are extremely important, highly, very high quality, and extremely helpful for you to apply when you in your different cultural and political environment will take steps in order to implement Barnahus. This project of PROMISE has brought together professionals who have been extremely generous in sharing their experience, wisdom, and knowledge to develop strategy for enriched conceptualization of Barnahus and deepened our understanding of how to ensure the transferability of the model across culture. Now, I beg your pardon for these troubles in my slides, but I hope you have found this to be informative. Thank you very much.